The Emerging Issues Forums are a program of the Strategic Planning Committee, which I have the pleasure of leading this year, along with our Vice Chair, Dan Hartman, and our terrific committee as in the whole. As you know, the legal landscape surrounding real estate is rapidly evolving, and it's essential for realtors to stay informed and prepared. Today's session will focus on the litigation that's been making headlines beyond NAR's lawsuit and resulting settlement. Some of them may seem overwhelming, others misleading, but all are important to understand. Our goal today is to break it down, recent legal cases, clarify the laws behind them, and explore how these developments impact our work as real estate professionals. We'll also look ahead to emerging topics that agents should be paying attention to. To guide us through this complex and timely topic, we're thrilled to welcome Trista Kurzidlo, Esquire. Trista brings a unique blend of expertise and engaging delivery. She's a graduate of Washburn University School of Law, where she was a member of the Washburn Law Review Journal. After serving as assistant legal counsel to Kansas Governor Bill Graves, Trista joined the office of the district attorney for the 18th Judicial District of Kansas and as an assistant district attorney assigned to the Consumer Fraud Division. From 2004 to 2010, Trista was the government affairs director and legal counsel for the Wichita Area Association of Realtors and the South Central Kansas MLS in Wichita, Kansas. She now devotes her time to offering excellent educational opportunities, for which I've heard about today from other people in the conference. And her sessions are known for combining the knowledge you expect from an attorney with the sense of humor you wish your attorney had. She has a strong grasp as to the why behind difficult legal topics and delivers the how of risk management in a way that's both accessible and enjoyable. Please join me in welcoming Trista to the stage. Take it away.
Thank you. Good afternoon. The staff was so worried and they kept asking me if I would be okay with the stage with my boot. And I was like, yeah, how else will they see how cute my other shoe is? And that's awesome. So as she said, I'm Trista Kurzidlo, and I am, much to the embarrassment and chagrin of my parents, an attorney. Let me. Being an attorney makes me the least educated of their children. And as they repeatedly tell me, I am a doctor who cannot prescribe narcotics, so that was a waste of 7 years. I tell you that because I think we should all, bond over my trauma, and also because I'm not licensed to practice law in Missouri, and so I'm not giving legal guidance. We are just a few hundred close personal friends having a conversation about the law. Okay, it might be a while, but usually somebody winks back, it's a whole. All right. So when I started thinking about what I wanted to talk about for emerging issues, what really came to mind went a little bit beyond litigation, and it was actually the results of litigation. And so I did a little what I would call crystal ball gazing. Where do I think we are headed? And for me, it starts with Chevron deference, and then changes that will happen in the Trump administration when it comes to the enforcement of the laws that regulate your industry. And then antitrust is not over. And being in Missouri, I kind of feel like you're the center of the antitrust universe, and you are probably sick and tired of it. But yeah, it's not over. There's so much more to come. So let's get started with Chevron deference. Now, when the Chevron deference decision came down, it was 40 years ago, and what the case basically said is that if Congress adopts a law and it's ambiguous, if it's not clear what it means, then the agency that enforces that law gets to interpret it. They get to issue guidance and kind of, different ways that they're going to enforce it, which also means that they get to embrace and enlarge definitions. Now, the Chevron deference, when that went into place, for 40 years, we've relied on that. And then in 2024, a really interesting case was decided, and a lot of people ignored it because it's about fishermen, and it's not very sexy. Because the other cases that were coming out of the Supremes at the time dealt with things like guns and different constitutional freedoms. And somehow fishermen just got passed over. But this is the one that's going to impact you the most. So what happened is some Atlantic fishermen claimed that the National Marine Fisheries Services, now the NMFS have a rule on how you regulate fishermen, and one of those rules required that the fishermen had to pay to have the enforcement officer on their boat. And the response from the fishermen was, we shouldn't have to pay to have your guy on our boat telling us what to do. You've overreached what the law was meant to do. And so they sue. And the original court says, Chevron deference. If the NFMS says you're paying for the guy on the boat, you're paying for the guy on the boat. But then we go to the appellate court who affirms it, and then it goes to the Supremes. And the Supremes issue this opinion in June of 2024, and they say no. The court interprets law. Agencies enforce it. And we're going to interpret it. And so what we take away from that, with the Chevron deference being completely overturned, is we look at what rules, what guidelines have we received from agencies like HUD, who enforce the laws that regulate our industry, that might now be subject to litigation, where HUD's not going to be able to say, we get to define ambiguous terms. And now we're going to have the court say, we define those terms. So I think the big four that we really need to watch out for are going to start with this one. And it is by far the one that I have, other than weed, which Bobby Howe will tell you I answer a lot of questions about. This is the one that I get the most questions about, and it's support versus service animals. And in 2020, FHEO 2020-01 was dropped by HUD, and it clarifies when a support animal is to be allowed in a property as opposed to a service animal. And it defines those two terms. I think this is going to be a source of litigation in the coming years. And then in 2016, we had Reducing Racial Disparities in Housing Opportunity Statement that was issued by HUD. For those of you who are property managers again, you probably remember this one because it impacted how and when you would conduct criminal background checks on potential tenants. And I think we'll see litigation on this one. And then in 2016, we also had the Limited English Proficiency Statement. And the Limited English Proficiency Statement is where HUD said, okay, we think there's enough of a connection when it comes to national origin and having limited English that not being able to speak English would fall under protection. And then it became one of our protected bases, or fell into one of our protected bases. I think we'll see issues with this one as well under the current administration. And then this is the big one, the 2012 Equal Access Rule. Now the 2012, I'm just going to tell you what it does and why we've got it. So this is when we're going to talk about sex. Now, in 1968, when the Fair Housing Act was adopted, it had 4 protected bases, something about me that was protected. And they included race, color, religion, and national origin. Then in 1974, sex was added as a protected basis. Now, 1974, sex not as interesting as it is in 2025. And when Congress adopted this, they were referring to, is an individual male or female, as indicated on their birth certificate by the doctor who delivered them. That's what 1974 sex was. And then in 2012, the Equal Access to Housing and HUD programs, regardless of sexual orientation or gender identity rule, was dropped. So a lot of folks will call this the Equal Access Rule. For a while, it was the Lesbian, Gay, Bisexual, Transgender, Queer Questioning, Intersex, and Ally Equal Access Rule, which takes up a lot of space in someone's mouth when they say that. So we're just going to call it the Equal Access Rule. And the Equal Access Rule said, okay, if we have a housing program that is administered by HUD, so we have housing assistance and it's administered by HUD, or if we have a mortgage that's insured by the Federal Housing Administration, then service has to be provided without regard to marital status, sexual orientation, or gender identity. So when we have FHA insured mortgage or we have a HUD program, we put a little asterisk and we say we've also got these 3 protected bases. And they also included in that equal access rule the nonconformance with gender stereotypes, which expanded this role even further. So when we look at what the equal access rule did, is it adds our 4 new protected bases. Now, 2 of those exist within Article 10 of the National Association of Realtors Code of Ethics. So you're used to seeing the sexual orientation and gender identity that applies to you. But the 4 protected bases that HUD expanded this to not only are impacted because of Chevron deference and the Loper-Bright case, but they're also impacted by two cases and an executive order that was issued by President Trump. So the first one is Bostock versus Clayton County. And this is an employment law case. And they look at the Civil Rights Act of 1964 under Title VII, and the court says, we are going to include sexual orientation and gender identity within the definition of sex under this Civil Rights Act. And the response from various agencies, including HUD, was to issue memorandums saying, okay, we now have court guidance, not just us expanding the definition of sex. We now have court guidance saying that it bars discrimination based on sexual orientation and gender identity. But then this case comes along, the Department of Education versus Louisiana. And so this one's issued August of 2024, just a little bit after that Chevron deference case. And in this one, the Supreme Court issues a decision blocking the Department of Education from expanding the definition of sex discrimination under Title IX to include sexual orientation and gender identity. So this means now we have this case in play, so we have conflict. But this one comes from the Supremes. And then we have this guidance that was issued by President Trump. And it's a lot to say, so I'm going to read it. Defending women from gender ideology extremism and restoring biological truth to the federal government. What would we shorten that to? Yeah, it's that. Now, when he issues this executive order in January of this year, he defines what the policy of the United States is going to be when it comes to defining sex. And he dials it back to that 1974, where sex is male or female, they are not changeable. And then it goes further to say that sex is not a synonym for and does not include the concept of gender identity. So the result of this executive order is he directly calls for federal agencies that have adopted rules or that have issued guidance who have said sex now includes sexual orientation and gender identity to repeal that guidance. And so we see that happen in HUD with the equal access rule. And then we also see it happen with the guidance that was issued in 2021 from the Consumer Financial Protection Bureau. They had issued guidance clarifying that discrimination by lenders on the basis of sexual orientation and gender identity was illegal because it fell under the scope of sex. So the big change here is now we have gone back to where we were before 2012. We're back at where we started in 1974. But it also means that the Code of Ethics and our federal law aren't matching anymore. And so we now look at Article 10. That's the guidance that realtors should follow moving forward. Does that make sense? Why that's a shift for y'all? Okay. Now, what else does the Consumer Financial Protection Bureau enforce? It's a big one. Okay, let's talk about the CFPB a little bit. So in February of this year, the acting director and the CFPB still has no final director send an email to all of their employees saying, don't come to work because we're not working. And he also posted on X that pursuant to the Consumer Financial Protection Act, I have notified the Federal Reserve that the CFPB will not be taking its next draw of unappropriated funding because it is not reasonably necessary to carry out its duties. So we see a CFPB now that is saying no to funding and is decreasing its enforcement efforts. So immediately following this, I was at a meeting with a bunch of agents, and one of them said, well, the good thing is we don't have to worry about RESPA anymore. No, that's not how it works, everybody. It's just not. When you look at the history of the CFPB, they've enforced RESPA since 2011, and repeatedly directors of the CFPB have called on state attorneys general and state insurance commissioners and said, you can enforce RESPA, and you should when you see violations in your state. So we will see a decrease in CFPB enforcement, but I think we're also going to see an increase in state enforcement of RESPA violations. So do not run out and start violating the law, because I watched y'all walk in here and none of you will flourish in prison, especially not in that jacket, all right? You look good in orange, but not that good, my friend, all right? Civil litigation is also available. And I want to point that out because what other federal laws have we dealt with regularly of late where we have seen that civil litigation come into play? Antitrust, right? It's been one of the major issues that you have had to deal with. And so when we talk about antitrust, and I think most of you will probably say you are antitrusted out, but I want us to look at where antitrust litigation is going, because it is a changing trend. And so when we look at antitrust in real estate, we have to, regulators mount up. Who are we dealing with? And we have the Sherman Act, we have the Clayton Act, and we have the Federal Trade Commission Act. Now, the FTC Act is one that we really haven't heard a lot about, but we should look at, because it is presumed that if we have a violation of the Sherman Act, we also have a violation of the Federal Trade Commission Act. So now we really have two barrels that can be pointed at you, right? Two barrels in the gun. And I want us to look at the Sherman Act in particular to see about potential violations. And so the Sherman Act reads, every contract, combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce among the several states or with foreign nations is declared to be illegal. Now, how many of you read that whole paragraph and you're like, I get it. I know exactly what that means. How many of you are like, I have no idea how we could possibly have violated anything that says conspiracy so many times, as well as talking about a conspiracy for restraint of trade among states? It's confusing language. But when we break down what the Sherman Act really means and who enforces it, it starts to make a lot more sense. So enforcement comes from the Department of Justice Antitrust Division. Now, state attorneys general can also bring federal antitrust suits on behalf of their residents, and then private parties can bring those suits as well. Now, why do we talk so much about this? Because we have criminal penalties. Again, that's prison time. Fines of not more than $1 million, imprisonment of up to 10 years, with corporations facing fines of not more than $100 million. Man, that one's squeaky. I gotta stay clear of that. The volume of commerce drives the sentence for both. Restitution can be paid to identified victims. And then we also have those civil litigation claims that result in treble damages, which is 3 times the demonstrated damages. Now, I want to break this down a little further, because this is where some people kind of run into the weeds, if you will. So we have our big 3. And they're price fixing, bid rigging, and market allocation. And we call them the big 3 because it's a different standard that has to be proven if you're alleged to have violated the Antitrust Act. And those fall under what we call a per se. Now, historically, per se standing was only held by governmental entities. But in our most recent rounds of litigation, we saw per se applied when we had litigation brought by a private party. Now, when we have a per se case that's brought and that per se standard, the standard that has to be proven by the party bringing the case is dropped down, and I don't have to prove, if I bring that case, that the agreement was successful, that it resulted in any damage or any harm. You can be found guilty even if the conduct was not unreasonable and lacked economic jurisdiction. All that has to be proven is that you met 5 different standards, but those standards didn't actually have to result in any harm. Now, when we look at those standards and what constitutes a violation, we have agreements to charge the same price or to raise prices together, to add fees or surcharges, to eliminate discounts or have uniform discounts, to establish minimum prices, and this is the ouch, to establish a standard pricing formula. And we're going to come back to that one. And then to coordinate and not compete on other commercial terms. So what I have to prove, the 4 elements of the violation, is that the charged conspiracy was knowingly formed and was in existence at or about the time alleged, that the defendant knowingly joined the charged conspiracy or intended to agree, and that's the big part right there, intended to agree. The charged conspiracy either substantially affected interstate or foreign commerce or occurred within the flow of commerce. Now, every time I talk about antitrust, somebody will say, Trista, real estate doesn't move. Like, you can't load up a plot of land and take it across state lines. And that's what interstate commerce is. But when we look at your actual business models, what constitutes interstate commerce, I gotta ask a few questions. How many of you have a Facebook page where you advertise your business? Interstate commerce. How many of you have your own website? Interstate commerce. How many of you have ever worked with a client who was moving into Missouri from another state? Interstate commerce. How many of you have ever worked with a buyer whose mortgage was with a bank that was out of state or had out of state locations? That's interstate commerce. All of your transactions fall within the scope of interstate commerce, even though your business is very local. And then we have our statute of limitations. So let's take a look at that big one, that conspiracy. Now, when we look at what constitutes conspiracy, it's a very broad definition. And what it boils down to isn't that you acted. It isn't that anyone took action, it's that you agreed. Now, can you silently agree? Is not saying something is wrong with a proposal going to be taken as that agreement? Potentially. Knowingly joined falls under mere knowledge of the conspiracy, doesn't actually make you part of the conspiracy, but you have to be able to defend that none of your actions were based on the information that was part of that conspiracy. Now, I want us to look at this from a different perspective, okay? So let's, everybody take off your real estate hats, all right? You're not real estate agents. All right, now, okay, your name? Nate, because we know Nate Johnson. We actually know each other. Okay, so Nate, you're gonna stay a realtor, okay? You're a realtor. And fall jacket guy, Jared, okay, you are also a realtor, okay? Now, Nate, you have an awesome listing. And Jared, you have somebody who wants to buy that listing. So your potential buyer has written a contract, but your buyer is old school and they want to sign a piece of paper with a pen. And you are gonna have this written document and they want you to deliver that to Nate, all right? Now, Nate, your listing has a deadline. Offers have to be submitted by 5, okay? Deadline in place. But the night that Jared has his offer to submit to you, there's a horrible snowstorm. It's awful, all right? And Jared just goes through that snowstorm to deliver that written offer, that contract. And you, Nate, have failed to have your parking lot snow removed. It hasn't been plowed. And Jared, you fall delivering that contract because you worked that hard for your client. And you fall and you hurt yourself. What do? It's America. What do? You sue, all right? It is not Canada. You sue, all right? So Jared sues Nate. Now, Jared, you need an attorney, all right? No, you don't get me, all right? So who do you want to hire? Look around. Which one of your peers do you think should be your attorney? Amber? All right. Amber, you're going to be Jared's attorney. So you guys meet, and you're like, Jared, this is a great case. Nate failed to have his parking lot plowed. It's a place of business. You were conducting business. You slipped and you fell. That is cake. And Jared's like, listen, Amber, I'm an independent business owner. I have not made a ton of money. I don't know how I will pay you because there are a lot of costs that are associated with litigation. So Amber says, here's the deal, Jared. Here's what we're going to do. I will pay filing fees. I will pay expert testimony fees. I will pay everything that's associated with bringing this lawsuit. I got that on me, all right? Now, you want to know how Amber's going to get paid. So Amber says, here's the deal, Jared. If we settle before we get to trial, you're going to pay me, what do you think is fair, like 30, 35, 40? 40? You look like a 40% lady, all right? 40% of what Jared makes if we settle before going to trial, all right? Now, Amber, I have this in place for me, and I think everyone should have this in place. All attorneys should have this in place. If I have to go to trial, I have what I call the Spanx surtax. If I have to wear Spanx to represent you, I charge more, all right? If I have to go into court with you, I charge more. If we can have a conversation where I am in my pajamas, I charge less. And you have the same, all right? So you say, here's the deal, Jared. If we have to go to trial, it's 50% of what you take when you make your successful claim, all right? So that is, you have skin in the game now, Amber, right? If Amber doesn't win, Amber's out everything she's put in to getting that litigation where it's at, right? So you have skin in the game. You don't want to lose. Now, Nate, you need an attorney. Who do you want? You want me, all right? Absolutely. I am your best choice. So Nate comes to me and he's like, Trista, I need an attorney. And I'm like, Nate, you do need an attorney. This is bad. And Nate explains, hey, here's the deal. I notified as many people as I could using the tools that I had that our office was closing early because of the snowstorm. We were going to extend that 5 o'clock deadline, and I asked nobody to come. I asked everybody, don't come. My office is closed. And then you closed the gate on your fenced-in parking lot and locked it. And you have video of Jared climbing over the fence to come into the parking lot, clutching that contract in his hands. I'm like, Nate, this is looking good, right? This is looking good. And Nate's like, but here's the deal, Trista. I'm an independent business owner. How am I going to pay you? Now, my response to Nate in this situation is going to be, it's fine. Don't worry about it, Nate, because Amber and I already have a deal. And Amber's going to pay me half of whatever she takes from Jared's settlement or what Jared takes away in litigation. Are you going to take it, Nate? Am I your attorney? What are you thinking, Nate? What goes through your mind when you hear that's how I get paid?
You have skin, you're incentivized for me to lose.
I want you to lose. I want you to pay Jared more because when Jared gets paid more, I get paid more. When we think about the litigation that y'all have been involved in, that's how your consumers think. They don't differentiate how it is that you're paid when you're representing that buyer. They look at that and they say, why would you want to negotiate a lower price for a house for me? You get paid more when I pay more. What is your skin in the game? Because it makes sense for when you're representing the seller, right? You have the skin in the game. You've paid for the advertising, all of the marketing, everything that has gone into that property to get it to where we have an offer. You've taken that on. And now the buyer's agent's done a ton of work as well. But when a consumer steps back and looks at that and they just look flat out, not understanding kind of the history of buyer's agency, they say, whoa, you want me to pay more to you and more for a house? That's where the Department of Justice is coming from when we look at the litigation that they're involved in now. So I want us to look at a case that's called NoSelect. And NoSelect versus MLS Penn is one where we get a really good idea of where the Department of Justice is coming from. So NAR is not a party to this because when we look at the MLS Penn, it's broker owned. It's not a realtor association owned multiple list. It's independent. Now, part of the litigation that we've seen so far has talked about the importance of the link between the National Association and the MLSs. And part of the numbers that are associated there is 90% or well over 90% of MLSs are owned and controlled by an entity that adopts the NAR rules because they're realtor-owned MLSs. And so that means when you look at the actual number of listings in the United States, well over 90% of all sellers are listing their property in an MLS that follows NAR rules. So it makes sense when we look at the settlement and everything that's been associated so far with antitrust, but NoSelect is different because it's not an NAR affiliated, but they follow a policy very similar to the policy that was called into question in our recent litigation. Now, MLS Penn settles, but they deny any wrongdoing. They say, we did not do anything. They agree to allow zero in a blanket offer of compensation line in their contracts, and then they agree to pay $3 million. Now, this is where it gets really spicy, and I want us to look at where the money goes. So out of the $3 million, $900,000 goes to the attorneys because my shoes are expensive. $200,000 goes for expenses, $250,000 for notification of class members. The named plaintiffs walk with $2,500. NoSelect, who claims to be harmed, walks with $2,500. And the attorneys, $900,000. Do you see the gleam in my eye? And that's where attorneys are coming from when we look at this. Now, the remaining funds are to be used to continue litigation against the parties that did not settle. And that's going to mean our Anywhere, our RE/MAX, Keller Williams Home Services of America. No funds are earmarked for any members of the class. None of the plaintiffs, except for NoSelect, get a dime out of the MLS settlement. Now, the judge initially questions the settlement, saying, we should probably actually have monies going to the harmed parties, but they eventually approve it in September of 23. And then in October of 2023, the Department of Justice enters a statement where they say, we have concerns over the settlement. We really don't like where this is going. And they also say that they have concerns with blanket offers of compensation. Now, when we look at what they actually say, this is where I think we get where is the Department of Justice coming from. So this is where we can kind of look at that crystal ball and say, what is our future when it comes to this type of litigation? So it goes into saying that the proposed settlement between the parties is not going to eliminate the anti-competitiveness. And they look at the history when they're making this statement. And it starts with really when buyer's agency was adopted. And so in the up until the early 80s, we did not have buyer's agents. We had seller's agents and sub-agents of the seller. So it made sense then that the seller's agent would have a pot of money at the end of a transaction, and a portion of that would go to them, and then a portion would also go to their sub-agent. Both of those entities having duty to the sellers. That made sense. But when buyer's agency came along in the early 80s after a study was done by the Federal Trade Commission where they asked home buyers, did you have an agent? And those home buyers said, yeah, I had somebody looking out for me. They discovered that those home buyers had no idea that the lady whose Cadillac they were being driven around in actually had a duty to the seller and not to them. And as a result, buyer's agencies created. Now, when it was created, there was no shift in the way that compensation was going to be handled. So it leads us to where we are now. And when the DOJ kind of traces then all of the litigation that has followed, and there has been a lot, they've looked at the numbers. And they've said, when we've had these changes as a result of litigation, were the numbers that were being involved with compensation changed? And they didn't, ever. So the DOJ is saying, we know historically when we've had compensation litigation, it hasn't resulted in any changes. And so we don't think that this one settlement is going to result in a change. And so we don't like it. So what they actually call for is uncoupling. And so when we think about uncoupling, does anyone immediately think of Gwyneth Paltrow, Chris Martin, conscious uncoupling? Because that's really what they're calling for. They want buyer's agents and seller's agents to break up. They want seller's agents and sellers to directly negotiate. They want buyer's agents and buyers to directly negotiate, and the two aren't going to be involved with one another anymore. It's a breakup. And so when they talk about uncoupling, they say, as long as sellers can make buyer-broker commission offers, they will continue to offer, quote, customary commissions out of fear that buyer brokers will direct buyers away from listings with lower commissions, a well-documented phenomenon known as steering. And that's where they look at the history when it comes to how agency litigation has changed or not changed your compensation structure. When sellers make such offers, buyer brokers need not compete on price to attract buyers. Now, they go on to explain what they would like to see, and then they say this. Buyers would likely prefer a fee structure that does not reward their broker for helping them to pay more for a home. So we know exactly where they're coming from, which leads us to this case, the U.S. versus National Association of Realtors. So back in 2020, the Department of Justice claimed that NAR was engaged in several antitrust behaviors. And NAR began negotiating with the Department of Justice, and they came up with a settlement. And they said, here's what we're going to do. Department of Justice, dismiss your litigation against us. And so as a result of that, NAR made some changes. Well, in 2020, we had one presidential administration, and then we have a different administration come in, and in 2021, the Department of Justice says, we don't like the previous administration's settlement, we're just not gonna follow it. We're gonna withdraw it. And so the realtors sue, and they say, hey, a change in administration does not give you the ability to withdraw out of this agreement. We negotiated in good faith, we have a settlement. And in January of 2023, the court determined that a change in administration did not allow the DOJ to withdraw from the agreement, and they reinstated it, which was a really big victory, but it didn't end that way. Because the Department of Justice appeals the ruling of the district court reinstating the agreement. And so in December of 23, the Court of Appeals heard arguments concerning the matter. And then April 5th of 24, the court issues its decision, and it's not awesome. Because what the decision says is that the settlement agreement reached by the Department of Justice and NAR in November of 2020 doesn't prevent the Department of Justice from reopening its investigation into the trade group's participation rule and clear cooperation policy. So basically the decision green lights the Department of Justice once again bringing new litigation and new case against the National Association. And since we have what they want made clear in NOSELEC, I think we're going to see this go forward. I think we're going to see more of this in the coming years. And then we have my latest obsession, which is RealPage. Now, are any of you property managers? Okay, do you use RealPage software? Okay, RealPage software allows you to do pretty much everything that has to do with property management. So you can collect your rent with RealPage software. It will do tenant background checks for you. It will provide leases. It provides everything. And then it has this really cool program, okay? And the really cool program works this way. So let's say everyone in this front row, all 5 of you, you are all property managers, okay? And between you, you're all out of, where do y'all want to be, like St. Joe? Does that sound good? Yes. Okay. St. Louis. What's a little, you're going to be from Knob Noster, Missouri. All right. Knob Noster, Missouri has 55 apartment units for a rent. Okay, that's it. 55 apartments in all of Knob Noster. Each of you have 10 doors, okay? So there are only 5 apartments that don't fall within this front row. You all say you're going to use RealPage. You provide RealPage with receipts here, how many units you have, what the quality of that unit is, and what your lease is. How much do you charge, okay? So they have the majority of the data is all held by RealPage coming from y'all with receipts. RealPage will then run numbers. And so let's say y'all have 100% tenancy. You are full. And Nate, you get an apartment that comes available. So you turn to RealPage and you say, RealPage, run the numbers. What can I charge for rent? Now the algorithm is going to look at what all y'all charge. And it's going to say, if we have 100% tenancy, we don't have units that are available to be rented. So you can hike your rent up because we're driving demand. RealPage will also run the numbers and say, Nate, if you just hold off on renting that unit, you will increase the demand even more. And we know from the receipts of your lease that you're going to have another unit come available in a designated amount of time, and you can really hike them then. Bobby, you'll also get an email from RealPage, and it will say, in 3 weeks, you're going to have an opening. Hold, because then we can really hike it because we're driving demand. What do you think? Antitrust violation? Do we have a group of competitors that are engaging in a program that results in them agreeing on a pricing formula? What do you think? Are we there? Now, RealPage has this amazing defense because they say, hold on, it's an algorithm. And algorithms can't break the law. That's awesome. That is awesome. And the former director of the Federal Trade Commission comes out and she's like, whoa, hold on here. I want you to think of this a different way. We're not going to look at this and say, you're feeding it into an algorithm. Instead, I want you to think of it this way, okay? So I got to pick on someone. I'm going to pick on you. All right, stand up. Okay. And your name? Brian. Okay, Brian, turn around. Look at all your peers. And instead of saying we're giving all of our information to an algorithm to give us this information, to give us what we should be setting our prices, we're going to give it to Brian. Do you trust Brian to hold on to all of your information and give you a fair, is that your wife? Who was that? Is your mom also a realtor? Because that would be who that is. Who said that?
You're the ones I trust.
If you wouldn't trust Brian, then don't trust an algorithm. So when we start looking, thanks Brian, you were awesome. If you wouldn't trust a person, Brian in particular, to take all of your data and then present and say, Bobby, this is what you should charge because this is what Nate's charging, then we're not going to feed it into an algorithm either. Now, RealPage is still pending, and I think we're going to see a lot more litigation as a result of artificial intelligence being used in our upcoming markets. So thank you guys for spending so much time with me.
Thank you.
Let's give Trista a round of applause, please. Lots to think about and lots to kind of soak in this evening, I guess. Thank you all for joining us for the emerging issues, and have a great night.